Hey everyone, I'm here with attorney Peter Martino. How are you doing today?
I'm great, Ahmad. How are you doing?
I'm doing great. Now, we're here today to talk about the benefits and drawbacks of alternative dispute resolution methods like mediation and arbitration.
Great. Well, first of all, let me tell you that there are two different things, mediation and arbitration. Let me take each in turn. Mediation can be very effective towards resolving disputes, and this can happen in any legal dispute, whether it's a family law case or a civil litigation case or any other case. Mediation can work. Typically what happens, so that you're prepared, is that you're there with your attorney, um, or not if you're representing yourself pro se, and you're going to be in front of a mediator who's going to take your side and the other side together at first and then separately in breakout sessions to get a sense of what each party is seeking. The mediators are often retired judges, or skilled mediators in some other manner, and they try hard to resolve the conflict without the need for further court proceedings. Many courts actually require mediation, so you have a civil dispute, you get all the way through the discovery phase, and the court may say, hey, before we have a trial, you've got to go through mandatory mediation. And the reason is that many cases settle that way, and it takes a lot off the court docket, and it allows the swifter processing of claims and justice to happen more quickly. I'm a big fan of going through mediation, but you need to be prepared. You need to know your arguments well. You need to know what the other side's thinking, and you need to know where you're willing to go to. Typically, when both sides leave the mediation a little bit unhappy, you've probably but you've got a resolution. You probably did as best as you could have done. Now, then there's arbitration. I'm not as big a fan of arbitration, although I've been involved in several of them. The reason I'm not as big a fan of arbitration is there's generally no appeal. So if you're willing to, basically go in front of an arbitrator or a board of arbitrators without any ground for an appeal, because you want to get it done swiftly and you want a quick decision, and you think the facts are so much in your favor that that's the only way that they could go and that you're going to get what you seek, then maybe arbitration works for you. It's a little bit more rapid. The discovery rules are relaxed to some degree. It depends on the arbitrator and the arbitral forum. And instead of being in a courtroom, you're typically in a conference room. But you have to know that the decision of that arbitrator in most cases is absolutely final with no appeal. So I don't personally like that, because I find that everyone's a human being. Everyone can make mistakes. And arbitrators do make mistakes. And then the courts will say, hey, you guys entered into an agreement to arbitrate. Arbitrator made a decision. Unless there's some fraud or some criminal activity or some gross reason why that arbitrator shouldn't be honored in his or her award, then you've got no recourse here in the court system. So that's why I'm not a fan of it, although there is the ability to have a swifter outcome if you go through arbitration. So in general, two different forms. Mediation, highly encourage it. Arbitration, be careful.
That's awesome. Okay. And where can they find you? Where can they reach out to you if they're going through a situation where they think they might need this?
You can reach me at peter@onoslaw.com, HONOSLAW.com. Our website is also onoslaw.com. We have an office in Washington, D.C. On Connecticut Avenue. We practice law in D.C., Maryland, and New York.
Okay. Thank you for your time.
Thanks.